Good afternoon, everyone. My name is Lluc Cerda. I'm the managing partner of the Calgary office of Samfiru Tumarkin, Western Canada Employment Practice Lead. Thanks for joining us today. We are here to discuss your employment rights. For the next half hour, we are going to be answering as many of your employment law questions as we can. So feel free to put your questions into the chat. We're going to get to as many of them as we can. We've already got some coming in, so let's begin. I have a question coming in here from Alicia P. Alicia is asking, I work for a federally regulated employer who recently discovered that they are not compliant with the Canada Labor Code regarding overtime. As a result, they reduced my hours from 60 to 40 hours per week. I guess what you're asking us there, Alicia, is what can you do about that? What are your options? So that's a reduction of 1/3 of your hours on a weekly basis. Essentially, what that means is just about any way you look at it, that probably amounts to a constructive dismissal. If your compensation has also been reduced by 1/3 as a result, that likely results in you having a claim for constructive dismissal, which is a situation where your employer hasn't said that they terminated you, but the way they're acting means that the job that you had, they don't no longer want to offer it to you. They want to give you a new job with substantially changed working conditions or terms, and it's up to you now to decide whether you want that new job or not. And if you want that new job, then go ahead and continue to work the 40 hours a week. If you don't want that new job and you have an opportunity to say, no, I do not accept these terms, this is a constructive dismissal. And what flows from that, though, is you are entitled to be paid your severance, just as though you'd been terminated on a without cause basis. So, how much severance are you entitled to? That's a very good question. We have a great severance pay calculator on our website that you can use free of charge. You answer 4 easy questions, and we'll let you know how much we think you're entitled to in severance. To access that calculator, simply go to pocketemploymentlawyer.ca. You have that there on the screen, and you'll go there. You'll get an estimate of how much severance you might be owed, and then so you'll have a decision to make. Alicia, you have either continue in the changed role that you're being presented with, or if you want to claim constructive dismissal and go after your severance, knowing that you would be leaving the role that you currently have, then feel free to reach out to us. We'll be happy to discuss that with you. If you want to reach out to us, we're at employmentlawyer.ca. You have the website right there on the screen, employmentlawyer.ca. Feel free to reach out. We'd be happy to chat with you. We have Morgan. I saw this comment come in before we actually started, complimenting us on our cool intro. Well, thank you, Morgan. I think it's pretty cool too. It was designed in-house by our producer, Dan Stone. We have another question coming in from YouTube from Sir. Sir is asking, I was rejected from getting rehired. The employer wanted someone with white skin. What is the criteria to determine if I'm more qualified? I have no disciplinary issues with my employer. Not a lot of detail of what actually happened here, sir. But let me tell you more generally about discrimination in employment practices. So you say you were looking to be rehired. So that can, I'm not exactly sure why you were getting rehired. Had you been laid off? Had you quit and now you were returning to the employment? Essentially, when you're a victim of discrimination in hiring, in the hiring process, basically you'll have to prove that, in this case, it seems to be the color of your skin played a role in you not getting the job. It's kind of easier said than done, unfortunately. No one's going to go out there and say, well, we only want people or applicants with this skin color. So I mean, you might suspect that that's a reason why you weren't selected for the role, even though you had the qualifications and all of that. But it's kind of tricky to make the leap that that you've proven that. Unfortunately, there are other areas where we see it a little bit more easily. If we want people who can perform certain tasks, for instance, and that might be discriminatory against people with certain restrictions, medical restrictions. If we want people with Canadian experience, for instance, that might be evidence of place of origin discrimination. If we want people to have a certain status in Canada, like citizen or permanent resident, that could be something that's discriminatory, and that'll oftentimes work itself right into the job posting. Or you might frankly be told, well, listen, you're here on a work visa. We don't want to hire you because of your employment status, of your immigration status. It's pretty easy to connect that your place of origin or your status in Canada played a role in the reason why you didn't get a job. So I guess what I'd ask you, sir, is do you have anything like tangible like that supports your assertion that the color of your skin played a role in you not getting hired? And like I said, it's one of those things that's a bit hard to prove, frankly, unfortunately. But I know it happens. I'm not denying that it happens, but it's hard, to prove that. People are pretty good in covering up their tracks on things like that now. But if there is something that you want to add to that, put it in the chat, and I'm happy to revisit this question later on in the show. So we have another question coming in from Jen. Jen asks, my manager says that I have done things wrong, but I haven't. He talks down to employees. I sent a complaint to HR, but was told no one else complained, which isn't true. HR also said if you're trying to get your manager fired, it's not going to happen. Is there anything I can do? HR says they will give him coaching, but the other employees that have complained were told the same thing, but nothing's changed. Okay, so, well, firstly, I want to just talk to you a little bit about harassment in the workplace, because this seems to be that you approached HR about your managers harassing and bullying behavior. So, in Canada, in the provinces where we operate, being BC, Alberta, and Ontario, all those provinces have anti-harassment legislation, which requires employers to investigate claims made by their employees of harassment, bullying, and even violence in the workplace. Okay, if you make a complaint like that to your human resources department, and they don't investigate it, then you have an opportunity to contact the Ministry of Labor, the Health and Safety branch of the Ministry of Labor, and have them make sure. They will send an investigator to the workplace, have them make sure that an investigation has been conducted. And if it hasn't been conducted, to require the employer to investigate the complaint. Now, that's as far as health and safety will go. Generally, they won't conduct the investigation for the employer. They won't tell the employer necessarily how to conduct the investigation. They won't review the investigative findings, but there will be an investigation at the very least. They will also review the employer's policies to make sure that their harassment policy is compliant with the legislation. So that's generally what they can do. Okay. Right. So those are your options to escalate it to the to the health and safety branch of your province's Ministry of Labor. And at the same time, I want to caution that it gets tricky when you're accusing your manager of harassing you or of bullying you, in this case, of bossing you around, essentially, because a manager's job is to boss you around, right? So, they aren't there to give you orders, to performance manage you, to tell you how to do things, right? And so what you have to show is that above and beyond what is expected from a manager in terms of, frankly, bossing you around, your manager is going above and beyond that in terms of how they're managing you. They might be raising their voice. They might be, throwing things. They might be micromanaging you or something. But the fact that your manager is managing you is not in itself discrimination. So something to keep in mind when you're not discrimination is not harassment. So something to keep in mind when you feel you're being, bossed around by your manager. It's got to be something above and beyond just basically being bossed around. So that's what I wanted to add there. But doesn't mean you can't make the complaint. No one can stop you from making a complaint. And if you've made a complaint and it hasn't been investigated, then like I said, go to the Ministry of Labor, the Health and Safety branch, and they will investigate, see what happened, why that hasn't been addressed yet by your employer. We have another question coming in from El Masoon. El is asking, my employer has reduced my commission structure. I work in sales and has given me 10 months notice, during which my pay remains unchanged from the period before the decrease. I have been with the company for 19 years. I'm 49 years old and I live in Ontario. Once the 11-month notice period ends, can they terminate my employment without providing severance pay? So what they've actually given you notice of is a reduction in your compensation. Okay. Now, whether or not 10 or 11 months is sufficient notice, you should be provided with the same amount of notice as you would based on the amount of severance you would get. So if you visit our pocketemploymentlawyer.ca, our website, you can use our severance pay calculator and get an estimate of how much severance in terms of months you're owed. So what they're giving you is, have they given you that amount of notice? And if they have, and I don't think they have, likely they've kind of been shortchanged you there. And at the end of that notice, they say, well, actually, we don't want to just reduce your commission structure. We want to terminate you. And we want to say that this 10 months of notice it gave you sufficient warning that your job was going to end. I would argue that's not exactly what they told you at all, right? They told you they'd reduce your commission structure, not that they would terminate you, so that your severance, if they do terminate you at the end of that, would be based on your total severance. And that notice period of 10 months that they gave you, I don't think would count, frankly, because it was a notice of something else happening, not what actually ended up happening, which is them terminating you. And if you get to the end of the 10-month period and they change your compensation, again, if they haven't provided you with enough months of notice, then you would be in a position to claim you've been constructively dismissed and go after the remaining amount of your notice. So definitely something to consider. It's a little bit convoluted what I've just explained to you. I think I understand in my head, but I can definitely appreciate that you might have lost track there. So this is one that you might need some tailored advice from one of us lawyers here on how to proceed forward. And I suggest you reach out to us and speak to us a little bit more specifically about your specific matter. If you want to reach out and get some guidance on how to proceed going forward, we're at employmentlawyer.ca. Feel free to reach out, okay? We'd be happy to help and give you a bit more tailored advice. We have a follow-up from Alicia. Alicia saying, thank you. They have told me this is not constructive dismissal and their offer is significantly less than I made before. So Alicia is the one who was working 60 hours a week and is getting her hours reduced to 40 hours a week. So Alicia, if you're telling me here that you're going to make significantly less than you did before, if that's true, that's basically constructive dismissal. I don't think they would admit necessarily that it is, but because that's the problem with constructive dismissal is the employer is always saying, no, us terminate you. No, we had no intention of doing that. But in fact, when you look at what's in front of you now, you have a completely different job, earning maybe a third, 2/3 of what you were previously earning, right? So sounds like that's a constructive dismissal to me. But I see here also, Alicia, you followed up that you've reached out to us, and we'll be setting up a consult with you very shortly. That's good on you. We'll be in touch with you very shortly. You can speak with one of us here and get again some tailored advice on how to move forward here with this claim of yours. Morgan's following up with the love for Dan. Morgan's the one who had complimented us on our opening and says, awesome job, Dan. And like I said, I wholeheartedly agree with that. Awesome job, Dan. Keep it up. Thank you, Morgan. We have another email, a question coming in from Henry K. Henry asks, my wife was hired after letting her employer know she was pregnant. Okay. They said it was no problem, but now that she is a few weeks before being off, they have told her, they have let her go, is what I understand here, and they have already hired a replacement. What can she do in this situation? Well, what I'll tell you, Henry, is that's an awful situation. I'm really sorry that your wife has to deal with that stress. A few weeks away from having your child. That should be a joyous moment, and now all that anxiety is creeping up. But I mean, if they've terminated her because she's pregnant or because she's going on maternity leave, well, there's a few things that flow from that. Firstly, that's not cause, right? So she's owed her severance. But secondly, that's looks to me like that's discrimination. So I call it pregnancy discrimination. There is no kind of protected ground for pregnancy, but it's generally included in gender discrimination. All right, so that's a form of gender discrimination against your wife, and when there is that kind of discrimination, essentially, not only is your wife entitled to her full severance, but she's also likely entitled to relief to make a claim under human rights legislation, which can be substantial amounts actually. If that discrimination is made out. So that would be her first step. I would say reach out to us, and we can help her, engage with her employer about this apparent violation of her human rights. One of the remedies, one of the things you can get from a human rights process is an order that your employer reinstate you into your position, along with the lost wages that you didn't earn between the day they terminated you and the day you're reinstated. So it can be a very good method to use, because of course when you're pursuing just your severance, there's never that opportunity to be reinstated into your position. But there are in other kind of areas. You have claims under human rights legislation. There would probably be a claim under the employment standards legislation in the province where you're located, Henry, to be reinstated with back pay. So definitely something that you can think that you can pursue there, and we're happy to help with that. Just reach out to us. The website was on the screen there a second ago, employmentlawyer.ca. We have another question coming in from Tinkerbell Rangella. Tinkerbell asks, hi, sir. If your employer cannot give you accommodation due to your limitations, what next steps do I need to do? Thank you. So, Tinkerbell, the requirement is that your employer provides you an accommodation of your restrictions up to the point of undue hardship. Okay. So what that means is, if it's absolutely impossible for the employer to accommodate you, then they don't have that obligation to accommodate you. All right. But if it's just a little kind of hard or involves some hardship to them, then they're expected to accommodate you. Okay. So I don't know exactly what kind of accommodation you were asking from your employer, but if you don't believe that accommodating you would cause undue hardship, then probably if they're refusing to accommodate you, and if you're refusing to allow you to come to work to earn a salary, then probably you would have a human rights claim under disability discrimination. So I'd have to understand a little bit more of what kind of accommodation you're asking for and what your restriction is and why they're saying they can't provide you with that accommodation to really be able to tell you whether that would amount to undue hardship or not. It would be very fact specific. But if it is true that they aren't accommodating you, then you can bring a human rights claim and also a constructive dismissal claim probably and pursue your severance and pursue human rights damages, potentially pursue reinstatement with an accommodated role and back pay and lost wages from the day you were told you couldn't be accommodated until the day that you're reinstated. Yeah, so there's definitely options to for you. Just kind of have to make an assessment of whether this is a situation where the employer could successfully argue that the accommodating you would amount to undue hardship. It's very hard for employers to do that, but it sometimes does happen. It kind of depends on what the accommodation is. All right. We have another question coming in from Ryan. Ryan is asking, I'm returning from a work injury and my employer is changing my title, hours, and pay, which goes against my employment contract. I believe this is a reprisal, discrimination, and constructive dismissal. So, Ryan, it may be. One thing I will note. One thing I'll note is a lot of people, when they come back from a workplace injury, require an accommodation. We were just talking about that a second ago, and that accommodation might make it kind of very hard for them to do the job they were doing before. Just to give an example, say you were a tech working in the field and you hurt your back and now you can't stand for more than 10 minutes or what have you, which makes it impossible for you to work in the field, and your employer offers you an accommodated role in their call center, for instance. All right. That may be a good accommodation, but the call center role might not pay as much as the field tech role would have paid, might have different hours and things like that, right? So yes, in normally being transferred from a field tech role to the customer service role might amount to a constructive dismissal. Here, because you can't do the field tech role, this is the accommodated position that's available to you. In that case, it might not be a constructive dismissal. So you haven't said whether you would require an accommodation to return to work from your injury. Supposing you're able to come back to work 100%, with no restrictions, then yes, absolutely. If they're if they're demoting you, changing your hours, changing your pay. For hours and pay, you're looking for a reduction of at least, I would say, if they're also changing your title, a reduction of at least 10% of hours and pay for that to amount to a constructive dismissal. Okay. And if like you said, you're the only reason this is happening is because you're coming back from leave, you don't need accommodations, you don't have restrictions, then it may very well be, as you said, also a reprisal and discrimination for you having taken a leave under that's allowed under workplace safety laws, employment standards, leaves that are available to you, and may also be human rights discrimination. So if you need help on how to navigate that, what's the best path forward for you here, feel free to reach out to us and let us know exactly a little bit more detail, about what I was saying. Do you require an accommodation to go back, or are you free of any restrictions? And then we can give you some more tailored advice on whether we think you have a claim here going forward. We'd be happy to talk with you, Ryan, about this. So feel free to reach out. That's at employmentlawyer.ca. Jen Scott is adding, yes, absolutely. I have emails of him gaslighting me and micromanaging me and others. HR said they investigated, but I'm not sure to what degree or if they didn't fully investigate. So there it is. Okay. Yes, Jen. Okay. Yeah. So Jen is the one who made a complaint to her HR department, who ignored her about her manager. So one thing I can tell you, how I was saying, the health and safety will send an investigator to see if an investigation was done and to see whether the harassment policy complies with the legislation. Well, one thing they'll make sure to do, there are some basic things that need to happen in an investigation. And one of those basic things, Jen, is you should receive an executive summary of the investigation findings. All right. So you're absolutely right that if you haven't received that, then you have no way of knowing whether your complaint has been investigated. So if you want to, push the envelope a little bit, you can contact the health and safety branch of your Ministry of Labor and have them come in and look into whether an investigation has happened. That's definitely an option that you have there, and they will basically order the employer, go ahead and investigate this complaint and provide Jen as required with a summary of the investigative findings. It won't have everything. It won't have verbatim, what people were asked or anything like that. And it won't tell you whether this person, this manager, will receive discipline or what kind of discipline. That's really up to the employer to decide whether there'll be any discipline or whether it's just coaching or a verbal warning or what have you. It's up to the employer to decide, but before they can decide that, they need to know, well, what exactly happened? What has the investigator found actually happened here? And you're entitled to receive a copy of the executive summary. Okay. We have another question coming in from YouTube from JX2. JX2 is asking, I work for multiple employers in BC, some unions, some not. Can I be disciplined for refusing to cross picket lines? That's a good question. It looks like if you were to cross a picket line, it's because you're crossing into a unionized setting. I'm just JX2. I don't want to be difficult, but I don't know who is disciplining you, whether the employer who would be disciplining you in this case would be unionized or not. I can only think of a unionized employer being the one to discipline you. I can imagine, for instance, a scenario where you work for a car manufacturer that makes car parts, right? And that is unionized. But you also work, for instance, doing deliveries for Amazon. So if you, as an Amazon delivery driver, refuse to go into the car part plant that's on strike, can Amazon discipline you in that situation? It kind of depends on why you can't cross. If you're not crossing because of union solidarity, I think probably Amazon could discipline you because you're not going in there to do scab work, right? You're going in there just to deliver deliveries essentially. If you're not crossing the picket line because you have concerns about your health and safety, and that's absolutely legitimate, right? If you're afraid that they might throw stuff at your car or stuff like that, that's absolutely legitimate. So I think, I don't know if this is a theoretical question or if this has happened to you, JX2, but I'd have to know a little bit more why you don't want to cross the picket line and whether this affects you in your non-unionized role, because I can't really comment on your unionized role. That would be covered by your union. We have another question coming in from Aim High. Aim High is asking if on LTD due to stress caused by your workplace, but when it's time to return, you don't want to go back. Is there any way to receive severance if you leave your job due to stress and toxicity? Well, what may be the case, Aim High, is that we'd have to hear more about what was so stressful and toxic about the workplace. But if it was so stressful that it made you sick, it's probably a constructive dismissal, frankly. We have to find out a little bit more about what happened there. But if it's causing you to need to go on LTD, it may amount to a constructive dismissal. So I think there is we have helped people exit, places that made them physically or mentally sick because of the working conditions and all of that. We've helped them exit workplaces like that. We have to get a little bit more detail about what it is that happened to you there. But definitely, I don't want you to think that you have no recourse here. So what I suggest you do is reach out to us at employmentlawyer.ca. Give us a little bit more detail of what exactly happened, and we can go from there and have you speak with one of our lawyers here and devise a path forward for you, because no one wants you to return to somewhere that's going to make you sick again. What's the point of that, right? So definitely. So we have JX2 is following up. My non-union employers are all aware that I also work for unionized employers. I never ran into a situation where I'd have to cross a picket line yet, but just thinking ahead. Yeah, so that's kind of the example that I had that came to mind, JX2. So for instance, you work in a unionized, car plant, and you have to cross, while you're doing deliveries as your second job. I mean, the problem with crossing picket lines is usually you're going in there to do kind of, like, for lack of a better word, scab work, right? Where you're replacing the striking the striking worker. If you're going there for other reasons, if you're delivering, I don't know what you'd be delivering through Amazon or UPS or Perlator or whatever, is the union really going to object to you crossing the line to go deliver that? I don't know. I've never been on a picket line. I don't know who they let in or what, but I don't think that would be an issue. But if you're refusing to do your job when you could do your job with no issues to health and safety, um, uh, that could amount to misconduct that would uh, attract discipline. Yeah, I think it would. Right. I don't think there's any laws, in the Labor Relations Act or anything like that would protect that kind of activity that I know of. Yeah. Ryan is asking, it has been 6 months since I have been cleared to return to work, and an employer has yet to accommodate. I just want to get my severance damages and just move on. Ryan is the one who's returning from a work injury, and now the employer is changing his hours and all of that. Ryan, I've seen it happen. I've seen how long it can last, where they're like sitting on their hands, wondering how they can accommodate your return to work. Ryan, I think if you're ready to move on, then I think you need to get in touch with us. All right, reach out to us at employmentlawyer.ca. The other thing is most human rights legislation allow you to sue, but only up to a year after the last discriminatory event. All right, so if it's been 6 months, nothing's happened on your file at work, then better to get in touch with us sooner rather than later, so you don't lose your right to make a claim under human rights. Okay, so really, I think right now, Ryan, the best bet is for you to reach out to us, employmentlawyer.ca. Tell us about what this new job is. Tell us about what your restrictions are, and get the lay of the land of whether you have an option going forward. Alicia is following up. If a federally regulated employer misclassified an office worker as a truck driver for 3 years and admitted in writing they misled them, is there a way to recover more than 2 years of overtime pay, owed overtime pay? Potentially, there is, Alicia. It's a long shot. So as I was just explaining to Ryan, you have a certain amount of time to make claims in general. Okay, so my understanding is that you can make a claim for the overtime pay through the labor program. You have for overtime pay stuff, you have 6 months to do it from the last breach. And if they find a violation of overtime in the last 6 months, the overtime legislation in the last 6 months, then they'll look at the past 2 years, which I think is the point where you're at right now. Okay, but they can only go back 2 years at the labor program. Okay, so generally, and we've gone over a little bit, so this will be my last question for today. Generally, you can, through the court system, perhaps argue that you should be allowed to go back, further than 2 years prior to your lawsuit, if you only discovered your claim within, a recent amount of time. So something might have happened to you 3 years ago, but you only discovered that it happened, just recently, right? It's easier said than done. I will tell you. Alicia. But if you want to discuss it, feel free to reach out to us. We can talk to you a little bit about that. I think you were gonna. I was gonna recommend that you reach out to us in any case to see whether this cut in pay and cut in hours amounts to a constructive dismissal, so we can discuss all of that at once at the when you reach out to us. Happy to do that. So sorry about all the people who have whose questions I haven't been able to answer. We have another show tomorrow at 1 p.m. Mountain Time. My colleague Karen Taraposky will be here to answer all your employment law questions that you have. We'll be happy to discuss that with you. My name, once again, is Lluc Cerda. I'm the managing partner of the Calgary office of Samfiru Tumarkin, the employment practice leader for Western Canada. It's been my pleasure, as always, to answer your great questions. Really, some very interesting questions today. Thanks for putting them in the chat. It was a great pleasure speaking with all of you, and I hope to see you soon. Bye now.